Ladies and gentlemen, welcome to the first Melbourne Marine Insurance Forum presentation for the year. Today we're honoured to have Maurice Lynch and Frazer Hunt from Mills Oakley Lawyers presenting on cargo insurance and insolvency. Their presentation is titled Welcome to the Hanjin, California. By brief way of background, Frazer's a partner at Mills Oakley working in the areas of transport, trade and insurance. He practices predominantly in transport-related matters and property claims. Frazer specialises in insurance and currently represents most of the marine insurers in Sydney, as well as various insurers in the UK and Europe. Frazer also advises several multinational logistics service providers and agribusiness interests and is an accredited specialist in commercial law. Frazer has been recognised as the leading transport, maritime and shipping lawyer in the 2017 and 2016 editions of the Legal 500 Asia Pacific and in the 2017 Australian Financial Review's Best Lawyers in Australia for Shipping and Maritime, Insurance and Transport Law, and has appeared on this list since 2009. Maurice Lynch is a Senior Associate at Mills Oakley Lawyers with over 8 years' experience. He represents marine insurers, federal government departments, freight forwarders, port corporations and general commercial clients. Maurice has represented clients in ship arrest proceedings in various jurisdictions globally and has completed his Masters of Law where he specialised in commercial, maritime and admiralty law. Maurice is also a published author, and today we would like you to put your hands together and welcome both Frazer and Maurice. Thank you very much.
Thanks, Dan, and good morning, everybody, and welcome to the first webinar as well. I understand that there are people out there in Etherland watching this. When I walked in, there was a commentary running down the side, and I had this terrible fear that it was going to be like one of those Twitter feeds where people send fairly rude comments about what you're saying. And fortunately, they've filled it up to the screen so they can scream all they like, and I just hope that we're coming through loud and clear. You can follow them, can't you, Adam, if they're not? Yeah, cool, thanks. Maurice and I came down on the 6 o'clock flight this morning. Luckily, we were not coming into Essen. I gather there's been a bit of an aircraft incident there, but we were there beforehand. This morning, we're here to discuss some of the issues faced by insurers following the recent shipping line collapses with Hanjin Shipping and more recently the collapse of Great Southern Shipping, which had at the time 3 vessels sitting on the water full of containers of merchandise which were due to be in Australia at least a month before Christmas. And I think some of them are still being delivered now. And so it's not been a very happy situation for the cargo owners who've backed what was meant to be a innovative new shipping line. It unfortunately failed on its first maiden voyage. My part of the presentation will identify some of the stakeholders involved in the supply chain and their attempts to minimise their exposures following the collapse of both of the shipping lines, which will hopefully provide a framework for Maurice to discuss the issues for the insurers in particular, where the cargo policies incorporating the 2009 version of the ICCA clauses, which I think is probably most of the Australian market, but he'll also touch on the 1982 version as well. The headline, Welcome to Hanjin, California, was basically a recycled headline from an article that I wrote fairly shortly after the collapse of the Hanjin shipping line, where I wrote an article which matched the lyrics of the Eagles' Hotel California, and which you can find if you Google. But certainly at that time, the actions of the various stakeholders as the events unfolded was a fine example of the adage, possession is 9/10 of the law, with people, all sorts of people in supply chain exercising liens over containers, often with questionable legal rights to do so, but the amounts involved really didn't warrant the intervention through the courts, which would have far exceeded the amounts that they were seeking to recover. With that, I'll just give you a few statistics. Hanjin had at the time 68 vessels stranded at sea or in port in 23 countries. They had also, that gives you an idea of the number of containers on board the vessels at the time. Indeed, they were moving something like 25,000 containers a day. One of our international freight forwarder clients had globally 5,000 containers on board. So I was speaking to their German lawyer. He described it as a shitstorm, which I think was probably a fairly apt description at the time. But it's not as if we haven't had this before. We've had ABC Container Line, STX. This won't be the last. At the time that Hanjin went under, it was arguably more solvent than Hyundai. And really, I think there are quite a few shipping lines up there that are there at the behest of their financiers for reasons that allowing them to collapse will suffer greater losses than if they continue to run. That in turn has some implications in relation to the insolvency provisions in the policies that Maurice will touch upon. I'm talking about I'm just going to go through some of what the stakeholders did at the time and what happened to them. I mean, with Hanjin themselves, after being put into liquidation, or into receivership, more accurately, they had basically abandoned all the voyages and were requesting security for the containers to have them returned, and occasionally even spoke on the phone. They were very difficult to get hold of because I think that with the stresses of the staff were, imagine if you're taking all these abusive calls from the shippers and the receivers, they suddenly thought, well, the company's going into liquidation anyway, so I think I'm just about to take leave. So they all went on holidays, and so there was nobody really there to answer the phones. But of course, nobody was moving the containers. That was only the start of people's problem. Of course, further down the line, you've got the terminal operators and the stevedores who were charging, assuming that they actually allowed the vessels into port, they were seeking security for either, if they weren't refusing to dock them, they were exercising liens over the containers as well for discharging costs, which I think was probably legitimate. But that in turn was creating logistical problems with the people having to arrange the appropriate security. They were, and then there was who were, I think, more questionably exercising a lien over the containers for wharfage fees, which were payable by the ship interests. But that eventually they backed down on that, which was rather lucky. But then that's where it started to get a little bit bizarre if you had dangerous goods, because the very same port authorities who were exercising a lien were saying, well, you've got dangerous goods, you haven't removed them from the wharf. It's now 3 days, and now I think that they were probably using the notice, they didn't change the notice. So in that context, when you get a message saying from the port authority that's exercising a lien on your container, they say, you are invited to present information on any difficulties encountered in complying with the permitted time periods on the terminal, which may be taken into account by the port authority when making a determination of the above alleged offence. Certainly we got a few rather exasperated calls from people who received those notices who just happened to have dangerous goods on board the vessels. Then you've got the cargo insurers. As I said, Maurice will deal with the marine insurance aspects of this in greater detail, but they were, I think on the whole, the insurers were either paying the on-forwarding charges or not, depending on the wordings, the individual wordings of the clauses, but they were having, I think most of the insurers who we spoke to really hadn't had this experience before with the insolvent shipping, and we were having to provide advice on how the insolvency clauses worked. and whether individual forwarding clauses were applicable. Also, people abandoning their cargoes and expecting the insurers to pick it up, and that just wasn't on. Of course, in any adversity, there's always an opportunity. The shipping lines who were not insolvent suddenly saw an opportunity to double or even triple their freight rates, and they were having to, they of course were refusing to take the Hanjin containers. So in the context of arranging the new shipments, if you were arranging it with another shipping line from whichever port the container was abandoned in, you were having to unpack the Hanjin container, repack it into another container, and then ship it on at great cost, and then trying to get it back. Obviously not from Hanjin, who were in liquidation, but from whether it was from the freight forwarder or whoever you could try and get a recovery from. So finally, you get the container off the wharf, you at the final destination, and then you try to redeliver it to the container parks. The container parks were just simply not taking the containers, which in turn for the receivers were creating issues with demurrage, container demurrage, because they had simply nowhere to return the containers. A lot of the shipping industry associations were working behind the scenes, managed to ultimately persuade container parks to take the containers. That's more or less been resolved now, but it took a while. People were asked to literally keep their containers, almost abandoning them on the streets and hoping that they weren't going to get stolen. That's a very unkind photograph of lawyers from our marketing department. There were many lawyers running around offering to give advice and helping, and quite often in times where there was very little they could do. We heard about some rivals who certainly none of them are in this room so far as I can see, who were trying to get a container off the Hanjin, California. Problem was that the Hanjin, California was berthed at a terminal that could not take a crane that was large enough to actually lift the container out, let alone the fact that the container was stowed about 3 under the deck. So quite a lot of fees were worked out running off to court to get orders, which they couldn't implement. Slightly embarrassing, but luckily none of the lawyers here were involved in that. Freight forwarders had their own problems because they were obviously trying to assist their clients move the containers forward and trying to do the best thing by them, but also then trying to work out whether or not they could recover the costs of doing so from the clients. And I think you'll find that more often than not, their terms and conditions, at least the ones that we've had to review recently, do not cover the situation where a subcontractor is insolvent. Of course, freight forwarders, if you're a shipper or a receiver, you'd be saying to the freight forwarder, well, we paid you good freight to move the goods from A to B, and you, thank you, we'll move it from A to B. And so the freight forwarders are ending up having to claim on their liability insurance, which is another topic for another day. With that, I'll just to talk about, and we'll field questions after that.
Thanks, Fraser. If you thought the facts were interesting, wait till you get into the intricacies of policy interpretation. So each marine insurance policy is different, but generally the policy will either incorporate the 1982 Institute cargo clauses or the 2009 clauses. I'll deal with the 82 cargo clauses first. In those clauses, the following is excluded, and that is loss or damage or expense which is approximately caused by delay, except general average and salvage charges, and that's clause 4.5, and loss or damage or expense arising from insolvency or financial default of the owners, managers, charterers, or operators of a vessel. So if you had a marine insurance policy incorporating the 1982 clauses, and in the absence of an on-forwarding clause, the additional costs incurred by a cargo owner in obtaining delivery of their cargo following Hanjin's termination of the contract of carriage would not be covered. So these costs could include additional freight costs and handling fees. So that meant that a cargo owner could not claim under the 82 clauses unless there was an on-forwarding clause. And the intention in the 82 clauses is clear that these types of claims are excluded from cover. In relation to the financial default exclusion, a person is said to be insolvent when he's unable to pay his debts in full. However, this clause extends to financial default, and that is much wider than insolvency and includes a situation where many ship owners and operators can still manage to continue trading. There would be also no cover under Clause 12 of the 82 clauses for extra charges properly and reasonably incurred in unloading, storing and forwarding the cargo to its final destination. And this is because Clause 12 is subject to the insolvency and financial default exclusion in Clause 4. Turning to the 2009 clauses, they are different. And importantly, the exclusions at Clause 4 are different. Clause 4.5 still excludes loss, damage or expense proximately caused by delay. However, Clause 4.6, which is the exclusion for insolvency and financial default, has been changed. Now, that clause states that the assured must be aware, or in the ordinary course of business could have been aware, that such insolvency or financial default could prevent the normal prosecution of the voyage. So we've introduced a knowledge test into that clause. And so it means that an insurer must prove that to rely upon this exclusion, must prove that the insured had knowledge that there was going to be an event of insolvency or financial default. Now, this is quite difficult to do. And in our view, we think that you probably have to prove that it's the governing mind of the assured who had that knowledge. And an insurer is going to have a great deal of difficulty in proving the governing mind has that knowledge, unless, of course, there was an insured who decided to ship cargo with Hanjin after Hanjin entered into receivership. I'm not aware of any assureds who did that, but that seems to us to be one of the few circumstances that exclusion would apply. So then we look at what sort of claims were arising under the 09 clauses, and generally they were claims under Clause 12 for forwarding charges. Now, for there to be covered under Clause 12, you must first show that there has been an all-risk loss covered under Clause 1. So you'll remember that the Institute Cargo Clauses 09 cover all risks of loss or damage except as excluded. Now, there is legal authority on this point, and loss or damage arising from insolvency is considered to be an all risk for the purposes of Clause 1. And there is a decision of London and Provincial Leather Processors in Hudson from 1939 that held where insolvency led to a loss of the goods or the adventure, which is the insured transit, that loss would be covered under an all-risk policy. Conclusion in that case is consistent with the fact that a marine insurance policy is not only covering loss or damage to goods, but it's also covering the voyage to which the goods are committed. So there's no need to be any actual physical loss or damage to the goods for an assured to make a claim under a policy for their forwarding charges. So it's the loss of a venture caused by the insolvency event or the financial default which triggers the cover. Alternatively, if the goods themselves are at risk of theft, misuse, or the enforcement of liens, the charges incurred in recovering goods would probably be covered under an all-risk policy, and that's the Integrated Containers decision for 1984. So if a cargo owner Hanjin had terminated a voyage in, say, Singapore, and a port authority had not been paid for services they applied to that container, and they were threatening the exercise of a lien, potentially an insurance policy could cover charges associated with allowing the on-forwarding of that container, the release from the lien, and it's sending to Australia. And this is a real risk in the context of Hanjin shipping, and it's a real risk in the context of any insolvency event with the carrier. So under the 2009 clauses, there's no cover if the loss is caused. There is cover for loss or damage expense arising for insolvency or financial default, provided the insured was not aware of the insolvency or financial default. So if Hanjin shipping terminated the marine transit at a port or place other than which the cargo insured it was covered under the insurance policy, then there was an insured could bring a claim for on forwarding charges, provided that loss or damage had not been caused by delay. In terms of the operation of clause 12, which is where the cover for the forwarding expenses applies, it does no more than clarify the position that forwarding and transshipment charges are recoverable as a sue and labour expense in order to avert a loss of the marine transit. And this is subject to Clause 4 exclusions. Clause 12 merely protects the right to claim for the loss of the marine transit and the right to sue and labour to prevent a constructive total loss of goods. The reference to extra charges in Clause 12 covers unloading, sorting and forwarding charges incurred to have the cargo travel to its final destination. But those charges must be extra. That is over and above what would have been paid. So for example, if the freight were only payable at destination, freight paid to complete the insured journey would not be recoverable unless it exceeded the unpaid freight amount. And the words unloading, storing and forwarding in Clause 12 are intended to cover all reasonable expenses, a broad cover under Clause 12. It's important to also remember Clause 9, and that's provision for cover where there's been termination of a contract of carriage or a change in the voyage. And these were two outcomes which occurred during Hanjin. And this cover under Clause 9 relates to the continuity of coverage, and it requires that prompt notice is given to the insurer, otherwise the cargo will terminate. So cargo owners need to be mindful of this and ensure the necessary representations are made to their insurers so the appropriate cover can be obtained once a carrier has terminated a voyage by reason of insolvency or financial default. Another thing to remember is that most cargo policies will include an accumulation clause, which allows for the increase in the policy limit where an accumulation of cargo occurs beyond the control of the insured. However, the right to such an increase is typically subject to prompt notification to insurers, so cargo owners should be mindful again of this point. What about recovery prospects for cargo insurers that have indemnified insureds on forwarding charges? This is going to be a very difficult area to obtain any recovery in. Of Hanjin, it's unlikely that Hanjin will have sufficient funds to make payment of such claims, and these claims will be unsecured in any insolvency. It's unlikely that Hanjin will have any insurance coverage for such claims, and the terms of the Hanjin shipping bills of lading provide that Hanjin does not guarantee delivery to the place of destination, and that it's excused from the consequences of non-delivery if such delivery is commercially unfeasible. And it would seem to us that in the context of insolvency, such delivery is commercially unfeasible. You may be able to have a claim against a P&I club or try and bring a claim against Hanjin's P&I club, but that will be a pay-to-be-paid policy, and it seems it will be unlikely that Hanjin will be with that. What are the lessons to be learnt here? Well, the issues arising out of Hanjin are not just limited to ocean carriers. A lot of talk about other carriers and the difficulties in the transport market at the moment. And we consider that this is not an isolated event for shipping lines, but we could also see these sorts of problems occurring with rail operators and inland carriers in Australia. So you need to be aware, and insurers need to be aware of how these clauses operate, both the 1982 Institute Cargo clauses and the 09 clauses. So that's Hanjin in a nutshell.
Do we have any questions in the room? And also, if anyone is following us on the webinar, you can submit any questions and Adam will read them out. Are there any questions?
What are the chances of pursuing the insurers pursuing recovery against the freight forwarders?
So the situation of freight forwarder would be a little bit different. Fraser's done a lot of work in that area, so I'll let him answer that question.
So the question of recovery from the freight forwarders.
By the insurer after settling the claim?
Well, the freight forwarders generally aren't the ones who have incurred the loss. When I say incurred the loss, it's usually the freight forwarders sometimes they've paid out on behalf of their shipping customers, but their prospects of recovery may be under a liability policy if they were in fact legally liable, but they've usually excluded their liability for such extra costs.
We've also had cases where at the port of transshipment, Hanjin has given up those containers, but Hanjin Shipping has asked the freight forwarder to pay for the first voyage, where the freight forwarder's agent has paid for that first voyage up to the transshipment and then notifies the agent in Melbourne. And the agent in Melbourne says, hey, wait a minute, we have paid for the whole voyage anyway. Would the insurers be liable to pay that part of it?
No, that would just be a commercial risk. And indeed, if I was the freight forwarder, I'd be quoting the Bible, go forth and multiply.
Yeah, but they had to do it because they wouldn't release the containers. And I'm talking of 50 containers.
Yeah.
So they wouldn't release the containers till they got the money.
They would probably.
No choice but to pay to release them.
We had one or two of those, and we ended up persuading Hanjin we could put up security for the freight because it was disputed. Although at the end of the day, that'll have to be settled because freight's generally earned at the time of shipment, and so it would be due and payable, and the receiver will be coming after.
The insurer had to pay it twice for the same freight. And the insurer had no choice, right?
I think that would be covered.
Yeah.
It's covered on the policy, and if seems to be the intention of these policies, that they do cover those situations where you pay your freight to Hanjin, and all of a sudden Hanjin's terminated the contract in Singapore, and you've had to then engage another shipping line to ship your container, and they are additional costs that would fall within the scope of clause 12, and so you would be able to claim under insurance policy for those costs.
I was just wondering, in relation to the lithium policy exclusion for insolvency plausible practices, are you aware of any instances in relation to Hanjin where insurers tried to rely on that exception and needed to prove knowledge of insolvency?
Question, I'll just repeat the question because of the webinar. The question is whether or not any insurers have, to our knowledge at least, sought to rely on the exclusion clause for insolvency. The answer, at least from our perspective, is no. We were asked to provide advice on it, but at the end of the day, with all the shipping lines that are effectively trading whilst insolvent, I think, and of course, as Maurice said, the need for it to really be the governing mind of the insured, I think that it would be very unlikely that an insurer would be able to rely on it because, again, being an exclusion clause, the ensuring that the insured, at least at the very top level, knew that the company was insolvent. I'm not aware of any, and indeed, if anybody else, whether they be insurers or lawyers in the room who have come across it, have seen someone rely on it. I'm getting a few heads. Sorry, John.
Denials under the 82 clause?
The very one or two that we saw, it was because they could rely on the insolvency exclusion because there was no carve out.
I might ask a quick follow-up if that's okay. What accounts for the change in that clause? There's some reason why that knowledge element was introduced into the clause.
I wasn't involved in the negotiations, or at least part of the negotiation. Well, the negotiations when I was much more involved in the lands were centering around Clause 8, which was where the transit started and finished. But in that context, I suspect that the feeling might have been that it was very unfair to expect a shipper to bear that risk. And indeed, the carve-out, when I say it speaks for itself, it's going to be very difficult for an insurer to rely on it.
I think probably if you're looking at what the purpose of the policy is, to cover also the transit itself, kind of fits in with that authority in the cases that's saying you're not only providing cover for the goods, but you're providing cover for the transit. And if you're looking at that, then it seems somewhat fair to have that carve-out narrow.
No other questions?
If there's no further questions, if you please put your hands together for Maurice and Frazer. Thank you very much. Maurice, please accept this on behalf of. Thank you very much.
Thanks, Judge.
Fuck the advertising, yes.
Yeah. I did, yeah.